A very good afternoon to all. I, Ms. Pratiksha Sable, Assistant Professor, Pharmaceutics Department of Konkan Gyanpit, Rahul Dharkar College of Pharmacy and Research Institute, Karjat, welcome you all for the webinar on Intellectual Property Rights in Pharmacy, organized by Institutions Innovation Council Cell. Before starting with the program, I would like to acknowledge the presence of our eminent speaker of the day, Pooja Kumar ma'am, founder and director of Innove Intellects LLP, and also Haneet ma'am. Thank you, ma'am, for accepting our invitation on such a short notice. Light is a symbol of brightness and prosperity. As sunlight expels the darkness of mind, similarly, blessings in a life bring prosperity and happiness. To make this webinar a blessed one, I request Poonam ma'am to virtually invoke Goddess Saraswati by kindling the lamp of knowledge and wisdom.
आरोग्यं धनसम्पदः शुभं कुरु त्वं कल्याणम् आरोग्यं धनसम्पदः शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तु ते दीपज्योतिर्नमोऽस्तु ते शुभं कुरु त्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरु त्वं कल्याणम् आरोग्यं धनसम्पदः.
Thank you, ma'am. With this positive vibes and blessing, we would proceed further. The Indian pharmaceutical industry has witnessed tremendous growth in the past decades in terms of market capturing and contribution to the gross domestic product of a country. India's domestic pharmaceutical market is estimated at USD 41 billion in 2021 and is likely to reach USD 65 billion by 2024 and further expand to USD 120 to 130 billion by 2030. Considering the promising future of the pharmaceutical industry, the Government of India is diligently involved in promoting this industry by introducing and enforcing regulations which are at par with the global standards. Due to the expansion of the market and the investment by the industry players, intellectual property rights protection becomes imperative for the companies. Patents provide pharma companies exclusive rights to the market drugs and prevent others to manufacture, sell, and make these drugs for a period of 20 years. IPR is a prerequisite for pharma companies for identification, planning, commercialization, and protection of invention. It is also an important tool to protect investment, time, and effort and encourages healthy competition, thus promoting industrial development and economic growth. IPRs also provide incentives to pharma companies to invest in research and development. The IPR protection works in numerous ways, like provides fair and effective incentive for innovation, protects pharma companies against potential infringers, provides strong enforcement tools for defending infringed patents. In a weak IPR protection economy, generic drug manufacturers imitate biopharmaceutical innovations without investing time and money to develop new medicines. As a result, branded drug manufacturers are unable to recoup investments in new drug development, thus finding it difficult to invest in research and development, that is R&D, of new drugs and costly diseases. A stronger IPR regime aids pharma companies in protecting innovation from the research to development stage. Creating, managing, and protecting intellectual property are becoming an important source of raising funds required for investment in R&D. IPRs also play a crucial role in mergers and acquisitions to target SME and the independent commodities that can be traded by way of licensing, joint ventures, etc. IPR has a significant impact in pharma industry from issues ranging from discovering, developing to pricing, distribution, competition mapping, availability, and pricing of new medicines. With stronger IPR protection in developed countries, The pharma companies are growing at a rapid rate. With this brief introduction about the intellectual property rights, now I feel great privilege and it's my honor to introduce to you the distinguished speaker of the day, Pooja Kumar ma'am. Pooja Kumar is founder and director of Innove Intellects LLP, established in 2007. She is also a registered patent agent and startup facilitator of Govt. of India and also an international speaker. She holds more than 15 years of experience in intellectual property rights field. She has won gold medals in master's degree in microbial and food technology from Punjab University, Patiala. Besides that, she had also qualified GATE exam in 2008 and Indian Patent Agent exam in 2010. She has delivered more than 200 awareness programs related to intellectual property rights. Recently, in 2020, she is recognized as top woman consultant for her contribution in the field of IPR. She has empaneled with Gujarat Innovation Council, MIET, KEC, ITS, Access College, ABS, Manipal University, Jaipur, and IIM Kashipur, Shivalik College, Dehradun, Mother University, Rokri, SRM College, Bareilly. She is not only creating IP awareness in India but also working for international countries. Recently, she has been invited as panelist in Nigeria for one IP radio station. Now, she is a mentor of JIIPCC South Africa for creating awareness for law students. She has received various awards and recognition in her professional journey, among which few are: she has received Senior Women Entrepreneur Award by GSIL Foundation, also awarded as Excellence in IPR Services given by Lokman, supported by MSPME, UP Government of India. She has also been awarded with Top Women's Consultant Certificate 2020, JIIPCC Mentorship South Africa, and Women Leadership Award. With this brief introduction, I once again welcome you, ma'am, and we are delighted to have you here. Now, without taking much time, I would like to hand over this session to you, ma'am. Over to you, ma'am.
Hello, hello.
Yes, madam, you are
Yes, I am
audible.
audible.
Yes, yes.
Hello.
Yes, ma'am, you are audible.
Yeah, yeah. So thank you for giving this my profile. And as I'm working with a lot of universities and colleges, as the today the lecture is about the importance of IPR in pharmaceutical. Pharmaceutical is a very great subject where we can protect the compositions, the process, the formulations, the kit. Okay, so these are that we can also file a patent for the molecule, the compounds. So there is a very broad scope in case of pharmaceutical industry when we are talking about the molecules and the kit. So the process of filing patents is like if you have developed any molecule and you have the results of that molecule, and for example, if you had developed some kit for malaria, for dengue, any for other disease, so for the device, it is patentable under the category of patent filing. And customers when we are going to file a patent for such type of things, because if your invention fall under section 3D, section 3D says कि section 3 means non patentable inventions, और सेक्शन 3D में बोलते हैं कि अगर आपने ऐसा कोई इन्वेंशन, ऐसा कोई मॉलिक्यूल पेटेंट फाइल किया है जिसका कोई सिनर्जिस्टिक या एफिकेसी अगर आप उसकी शो नहीं कर रहे हैं, तो वो मॉलिक्यूल पे पेटेंट लेना पॉसिबल नहीं है. जैसे फॉर एग्जांपल एस्प्रिन पेन किलर के लिए ऑलरेडी नोन है. अगर आप एस्पिरिन की नई प्रॉपर्टी निकाल के देते हैं और ऑलरेडी एक चीज के लिए पेटेंट ऑलरेडी फाइल्ड है, तो पेटेंट ऑफिस आपको ग्रांट नहीं करेगा कि आप उसके लिए पेटेंट फाइल करें. तो जब भी हम बात करते हैं कोई मॉलिक्यूल की फॉर्मुलेशन की, तो आप सिनर्जिस्टिक एफिकेसी रिजल्ट का हम उम्मीद करते हैं फार्मास्यूटिकल से, इंडस्ट्री से, कि जब आप रिसर्च में जा रहे हैं और पेटेंट आप फाइल करना चाहते हैं फार्मेसी से रिलेटेड, तो एफिकेसी रिजल्ट इज वेरी इंपॉर्टेंट to prove that you have worked on the such type of molecule which is far much better than already known compounds. Okay, so ज्यादातर जो फार्मास्यूटिकल के केस में जो इन्वेंशन फॉल करती है वो सेक्शन 3D और 3E आपका एडमिक्सचर्स को लेके, कि आप एडमिक्सचर्स अगर फाइल कर रहे हैं तो उसके क्या फायदा है, आपस में जो एडमिक्सचर्स है वो इंडिपेंडेंटली वर्क करेंगे, तभी पेटेंट ऑफिस कहता है कि तभी वो पेटेंटेबल होंगे। अदरवाइज जैसे सॉल्ट, अगर आप वाटर में आप सिर्फ नमक और चीनी का एक घोल बना रहे हैं, ठीक है, तो और आप उसका पेटेंट करना चाह रहे हैं, तो इट्स एडमिक्सचर, सिंपली आपने पानी और सॉल्ट को मिक्स कर दिया, देयर इज नथिंग कॉल्ड मिक्सचर इन दिस। तो ऐसी टाइप ऑफ इन्वेंशन को अगेन पेटेंट ऑफिस जो है आपको अलाउ नहीं करता। हमारे फार्मास्यूटिकल इंडस्ट्री में एक चीज और थोड़ी अच्छी है, वन इज फॉर कंपल्सरी लाइसेंस। जब हम बात करते हैं पेटेंट की, कि आपने पेटेंट ग्रांट करवा लिया, पेटेंट ग्रांट हो गया आपको, बट क्या कई बार क्या करते हैं, हम उन इन्वेंशन को लेके बैठ जाते हैं, ना तो हम उसको किसी को लाइसेंस करते हैं ना कमर्शलाइज करते हैं। तो अब ऐसी ऐसी कंडीशंस में अगर आपने कोई इन्वेंशन पेटेंट ले लिया और आप उसको मार्केट में बेच नहीं रहे, लोगों तक नहीं पहुंचा रहे, तो आप कंपल्सरी लाइसेंस के लिए ग्रांट कर सकते हैं, अप्लाई कर सकते हैं। तो नैटको वर्सेस हुआ था इंडिया के अंदर, नेटको और जो आपकी बेयर कंपनी, यू ऑल नो दे बोथ आर द फार्मास्यूटिकल कंपनी, एंटी कैंसर ड्रग बनाई थी बेयर ने। जब नेटको को ये पता चला कि ये कैंसर ड्रग है, ये मार्केट में अवेलेबल नहीं है, बाहर आउटसाइड इंडिया बेचते हैं बेयर जो है, और बहुत प्राइस भी बहुत हाई है, तो उसके लिए पेटेंट ऑफिस ने उसे कंट्रोलर को मेल डाली और कंपल्सरी लाइसेंस के लिए अप्लाई किया। और नैटको वर्सेस बेयर का, नैटको द फर्स्ट कंपनी हु विन दैट केस, और सबसे पहला जो कंपल्सरी लाइसेंस ग्रांट हुआ वो नैटको को ग्रांट हुआ। तो कंपल्सरी लाइसेंस का मतलब ही ये होता है कि जब कोई एपिडेमिक आ जाए या कोई इमरजेंसी आ जाए, या फिर अगर कोई प्रोडक्ट टेरिटरी में वर्क नहीं कर रहा है, अगर वो ग्रांटेड भी है, तो आप कंपल्सरी लाइसेंस। तो पेटेंट के लिए आपको दो चीजों का ध्यान रखना, वन इज कॉल्ड प्रोडक्ट पेटेंट, अनदर इज कॉल्ड प्रोसेस पेटेंट। प्रोडक्ट पेटेंट में आपका डिवाइसेस आती है, फॉर्मुलेशन आ जाते हैं, कॉम्पोजिशन आ जाती है। जब हम बात करते हैं फार्मास्यूटिकल कॉम्पोजिशन की, फार्मास्यूटिकल फॉर्मुलेशन की, तो वहां भी पेटेंट ऑफिस को एफिकेसी रिजल्ट्स की जरूरत होती है। जब तक आप एफिकेसी रिजल्ट नहीं देंगे तो पेटेंट ऑफिस आपके पेटेंट को ग्रांट नहीं कर सॉरी। तो जनरली इंटेलेक्चुअल प्रॉपर्टी का मतलब है क्रिएशन ऑफ ह्यूमन माइंड। आपके दिमाग में जो नई नई रिसर्च, नए नए इनोवेशन पे आप काम कर रहे हैं, उन रिसर्च को हम आईपीआर के थ्रू प्रोटेक्ट करते हैं। माय वॉइस इज ऑडिबल मैम?
Yes, madam, you are
मैम,
audible.
यस।
Yes, yes.
So intellectual property में we have different types of IPR. We have patents, trademark, copyright, design, GI, and trade secrets. Now, any invention developed by the inventor, the creator, the innovator, is that given to the inventor for their protection of the intellectual property rights. तो पेटेंट के जो राइट्स है वो आपको 20 ईयर्स के लिए दिए जाते हैं, ट्रेडमार्क के राइट्स आपको 10 ईयर्स के लिए दिए जाते हैं, डिजाइन भी आपको 10 ईयर्स के लिए दिया जाता है। तो हनी, can you slide? And today is a WIPO day, 26 April, and every this day to encourage what is a why this day is important, to encourage the innovations, to encourage the IPR, to protect the patent, trademark, copyright, and designs. That is why we are celebrating this IP day as the Intellectual Property Day. Okay. So, Hanif, can you please share the slide? Next slide. So next. Next. So what is intellectual property? I have already told you. These IP rights are recognized due to the following reasons, because these are the rights. जैसे आप अपना घर लेते हैं, आप अपनी कार लेते हैं, तो हम उसके ऊपर अपने राइट्स कब सिक्योर करते हैं? जब आप उसकी रजिस्ट्री करा लेते हैं। एक घर आप अपने नाम पे जब करा लेते हैं, देन यू से दैट दिस इज माय इंटेलेक्चुअल प्रॉपर्टी, दिस इज माय प्रॉपर्टी। सेम वे में जब हम एक पेटेंट, एक आइडिया को लेके चलते हैं, जब तक आप उसे फाइल नहीं कराएंगे, योर राइट्स विल नॉट सिक्योर। day you file the patent, the rights start from that day. That is very important point that you have to grab. The second important point that you have to think, कि जो रिसर्च हम लोग कर रहे हैं उसको आपको पहले पब्लिकेशन नहीं करना है। व्हाट हैपन कि हम लोग क्या करते हैं, अपने आइडिया को ही पहले पब्लिश कर देते हैं, उसके बाद पेटेंट फाइल करते हैं। तो पेटेंट ऑफिस का रूल है कि आप पहले अपने वर्क को पब्लिश नहीं करेंगे, पहले आप उसको पेटेंट करेंगे, उसके बाद ही आप उसका पेटेंट फाइलिंग पब्लिकेशन के लिए जाएंगे। ओके, अगर आपको एससीआई स्कूपर्स में कहीं भी पब्लिश करना है, पहले आप पेटेंट फाइल कीजिए, उसके बाद ही पब्लिकेशन के लिए मूव कीजिए। नेक्स्ट स्लाइड। So we have different types of intellectual property. We have patents, trademark, copyright, design, and GI. Next slide. So first category we have next slide. So you can see from this table the statistical data. Now the awareness of the people are increasing in the intellectual property right. पहले अगर हम 2015 की बात करते हैं वहां से और अब जो इंक्रीजिंग ट्रेंड है वो कितना बढ़ गया है। ओके, पहले आपका 46,000 एप्लीकेशन फाइल हुई थी 2015 से 16 को लेके, बट 2019 और 20 से 56,000 का ट्रेंड जो इंक्रीज हो गया। इट नॉट इन पेटेंट, डिजाइन, कॉपीराइट, ट्रेडमार्क में भी आप देख सकते हैं देयर इज अ स्टीप फॉल, नॉट फॉल, देयर इज स्टीप इंक्रीज इन द पेटेंट एप्लीकेशंस फ्रॉम राइजिंग फ्रॉम 2015 to 2020। नेक्स्ट स्लाइड। So why registration of IP is important? Registration of IP is important because it protects your legal rights. Legal rights को protect करता है, आपकी innovations को protect करता है। एक बार protection होने के बाद you can leave that other person. अगर कोई बंदा आपकी बिना permission के आपकी invention को use कर रहा है, so you have a right that you can sue that person, you can take that person in the court. So that is the importance of intellectual property rights. Patent के rights आपको 20 years के लिए आते हैं, 20 years के बाद आप उनको पूरे 20 years आप अपने rights को enjoy कर सकते हैं। Like other real property, you can excluding third person, but stopping the third person that you cannot use my intellectual property without my permission. So that is the importance of intellectual property rights. Now, after that, the creator has a liberty. Okay, the creator has a liberty to earn the lump sum amount of royalty from that. What is the importance of royalty? See, if you have developed a corona kit during this pandemic, okay, so this corona kit that you have developed and that you have filed a patent on this corona kit, so ultimately the company who is selling this corona kit, ultimately the company who get the rights of this corona kit to manufacture or sale, they get the royalties, they get the benefit of this technology. So that is the importance of patents, कि जो भी आप पेटेंट फाइल करते हैं, जब आप किसी कंपनी को उसको बेचते हैं तो उसके बदले में आपको उसके पैसे मिलते हैं, उसकी रॉयल्टी मिलती है। यही फायदा होता है पेटेंट्स का। नेक्स्ट स्लाइड। Organization of IP offices in India, we have different offices in India, like we have trademark design patents के हमारे 4 ऑफिसेज हैं, दिल्ली, मुंबई, चेन्नई एंड कलकत्ता। जो हमारे चारों ऑफिसेज में आप अपनी एप्लीकेशन ऑनलाइन और फिजिकल फाइलिंग के थ्रू फाइल कर सकते हैं। नेक्स्ट स्लाइड। वर्ल्ड इंटेलेक्चुअल प्रॉपर्टी ऑर्गेनाइजेशन, वाइपो एक ऐसा ऑर्गेनाइजेशन है जो टेक केयर करता है आपकी फॉरेन एप्लीकेशंस के लिए। अगर आप पीसीटी एप्लीकेशन फाइल करना चाहते हैं तो आप वाइपो के थ्रू पेटेंट फाइल कर सकते हैं। वाइपो में बेसिक एप्लीकेशन फाइल करने के बाद आपके पास ऑप्शन होता है कि आप मोर देन 130 कंट्रीज में जाके अपना पेटेंट फाइल कर सकते हैं। आपको वहां जाने की जरूरत नहीं है, एक सिंगल एप्लीकेशन को पीसीटी एप्लीकेशन फाइल कीजिए और आप उन सारी पीसीटी कंट्रीज के अंदर मूव कर जाते हैं। उसके बाद 30 और 31 फेज के बाद 30 और 31 जब टाइम पीरियड खत्म होता है, देन यू एंटर इनटू द नेशनल फेज। नेक्स्ट स्लाइड। नेक्स्ट स्लाइड। efforts made by DPIT to strengthen the IPR in India. See now, what is DPIT? स्टार्टअप की अगर हम बात करते हैं, स्टार्टअप कौन होता है? स्टार्टअप एक वो ऑर्गेनाइजेशन, वो एंटरप्रेन्योर जिसने अपना एक मिशन, एक इनोवेटिव अपने एक इनोवेटिव प्रोडक्ट को लेके वो मार्केट में लेके जाता है। इनोवेटिव प्रोडक्ट कुछ भी हो सकता है। ओके, उस इनोवेशन को जो मार्केट में लेके जा रहा है, कोई सर्विसेज जो मार्केट में लेके जा रहा है, वो एंटरप्रेन्योर उस स्टार्टअप को अगर अपने कंपनी को डीपीआईटी के अंदर रजिस्टर करता है तो उससे क्या बेनिफिट मिलेगा? डीपीआईटी आपको टैक्स के अंदर बेनिफिट देगी, डीपीआईटी आपको पेटेंट के अंदर बेनिफिट देगी। 80% का रिबेट दिया जाता है पेटेंट फाइलिंग में अगर आपके पास डीपीआईटी का सर्टिफिकेट है। तो डीपीआईटी के रिकॉर्ड्स के अकॉर्डिंगली एफर्ट्स मेड बाय डीपीआईटी, हमारे जो इंडिया है, इंडिया हमारे अगर हम कंपेयर करें इंटरनेशनल फाइलिंग में भी बहुत आगे निकल कर। नेक्स्ट। ट्रेडमार्क, जैसे कि आप साइट्स में देख रहे हैं, वी हैव डिफरेंट ट्रेडमार्क्स। एडिडास का है, बीएमडब्ल्यू। तो ट्रेडमार्क एक्चुअली में होता क्या है? ट्रेडमार्क का मतलब है कोई ब्रांड। जब आप किसी प्रोडक्ट मार्केट में कोई शूज चाहिए, मुझे नाइकी के शूज चाहिए, तो हम लोग क्या कहते हैं ब्रांड पर अट्रैक्ट हो रहे हैं। और ब्रांड को डिस्टिंग्विश करने के लिए कि ये कौन से प्रोडक्ट का ब्रांड है, तो उसके लिए ट्रेडमार्क इज ए ग्रेट इंपॉर्टेंस। ट्रेडमार्क आपको डिस्टिंग्विश करता है क्वालिटी ऑफ गुड्स एंड सर्विसेज के लिए। वर्ड मार्क फाइल कर सकते हैं, नेक्स्ट स्लाइड में वर्ड मार्क फाइल करते हैं हम, लेटर्स की फॉर्म में भी ट्रेडमार्क फाइल करते हैं। और आप जो रिंगटोन्स है ब्रिटानिया की, एयरटेल की रिंगटोन, उनकी भी ट्रेडमार्क फाइल करते हैं। वर्ड मार्क की बात कॉलेज है तो उसका लोगो है, उसको भी हम डिवाइस तीसरा बीएमडब्ल्यू, आईसीआई बैंक, इन सबको भी हम लेटर मतलब शॉर्ट फॉर्म से फाइल करते हैं। अभी शाहरुख खान ने एसआरके को भी ट्रेडमार्क के लिए फाइल किया है, तो एसआरके को कहीं पे भी वो यूज कर सकता है, किसी भी डिवाइसेस में वो यूज कर सकता है। नेक्स्ट स्लाइड। ट्रेडमार्क के राइट्स आपके 10 ईयर्स के लिए दिए जाते हैं। ट्रेडमार्क जो आपको नहीं मिलता है वो ऑयल फैक्ट्री, खुशबू वाली चीजों के लिए आपको ट्रेडमार्क नहीं मिलता है। नेक्स्ट स्लाइड। जब टीएम आप फाइल करते हो तो टीएम के लिए सबसे पहले इंपॉर्टेंट चीज आपको क्या देखनी है, टीएम आप 1 से लेके 45 क्लासेस के अंदर टीएम फाइल कर सकते हो। आप चाहो तो 45 क्लास में भी टीएम फाइल कर सकते हो, आप चाहो तो एक क्लास में भी टीएम फाइल कर सकते हो। जो 4500 आपको गवर्नमेंट फीस पे करनी होती है और 9000 आपको, अगर कॉर्पोरेट कोई ट्रेडमार्क फाइल कर रहा है तो 9000 रुपए पे करनी होती है। अब देखो एवरेस्ट मसाला और एवरेस्ट बैटरी बहुत सेम कॉमन नेम, ठीक है, बट दोनों को ट्रेडमार्क मिला हुआ है। क्यों? क्योंकि दोनों की क्लास अलग है। तो जब भी आप क्लास फाइल करें तो ये देखें कि जिस क्लास में आप ट्रेडमार्क लेना चाहते हो उस अवेलेबल नहीं होना। नेक्स्ट स्लाइड। केस स्टडी यहाँ पे मैंने सोनी की बहुत अच्छी केस स्टडी दी है। ट्रेडमार्क में इंफ्रिंजमेंट होता है। इंफ्रिंजमेंट क्या होता है? इंफ्रिंजमेंट होता है चोरी। आप जैसे हम घर में कोई भी चोर होता है, चोरी करता है, उसको जेल पहुंचाते हैं, पुलिस को देते हैं, वैसे ही हमारे पेटेंट में, आईपीआर में भी आपका, अगर कोई किसी की टेक्नोलॉजी को चोरी कर रहा है, ओके, तो उसको आप पूनम मैम,
Hello, madam.
हेलो।
Hello, your voice is breaking,
हाँ हाँ,
madam.
okay, then I'll hand over my system to Hanis. Hanis, are you there?
Yeah.
या हनीफ, यू कैन कंटिन्यू फर्दर। ये मैं केस स्टडी समझा देती हूँ। ट्रेडमार्क के बाद
Okay.
यू कैन कंटिन्यू फ्रॉम पेटेंट्स। ओके, सोनी का ये
Okay.
केस था जिसमें हाँ मैं ये बता देती हूँ। सोनी का ये केस था जिसमें सोनी ने ट्रेडमार्क इन्फ्रिंजमेंट फाइल किया। एक कंपनी, एक छोटी सी फर्म थी, सोनी ट्रैवल एंड टूरिज्म को सिल्वर मूर्ति के नाम। तो जो सिल्वर मूर्ति थे वो ओनर थे सोनी ट्रैवल एंड टूरिज्म के। तो उन्होंने, सोनी ने उसके ऊपर केस फाइल किया कि भाई तुमने मेरा सोनी नाम कैसे यूज किया। फाइनली लक्ष्मी, जो जज थी, लक्ष्मी कुमारी जो जज थी, उन्होंने डिसमिस किया ये केस और उन्होंने बोला सोनी को कि आप प्लेंटिफ ने जिसने केस फाइल किया सोनी कॉर्पोरेशन ने, उनको बोला कि आपको सोनी ट्रैवल एंड टूरिज्म को 25,000 रुपए पे करने हैं, बिकॉज उनकी दोनों की क्लास अलग थी। वो ट्रैवल का काम कर रहे हैं, आप म्यूजिक सिस्टम पे काम कर रहे हैं, आप टीवी बना रहे हैं, इलेक्ट्रॉनिक प्रोडक्ट्स बना रहे हैं, तो वो आपका नाम कैसे यूज कर रहे हैं? उनकी क्लास अलग है, आपकी क्लास अलग है। तो दैट इज द इम्पोर्टेंस के आपको, ये केस फिर सोनी हार गया, ठीक है, और वो सिल्वर मूर्ति जीत गया। क्योंकि आप अगर ये डिफरेंशिएट करते हैं कि आपका जो क्लास है वो बिल्कुल डिफरेंट है, चाहे नाम भले ही सेम हो, तो आप उसके ऊपर ट्रेडमार्क फाइल कर सकते हैं। दूसरी बात, आप जब ट्रेडमार्क के लिए जाते हैं तो वेल नोन ट्रेडमार्क्स है, जैसे फिलिप्स हुआ, एलजी हुआ, तो ये कुछ ऐसे वेल नोन ट्रेडमार्क्स है कि ये इन्होंने रजिस्टर्ड कराए हुए हैं और इनकी फीस भी थोड़ी ज्यादा होती है। तो अगर आपको लगता है कि मेरे बहुत सारे ब्रांड बनने वाले हैं, जैसे एमिटी यूनिवर्सिटी का मैं एग्जांपल देती हूँ। एमिटी बहुत बड़ा ब्रांड है और एमिटी अगर दुबई में यूनिवर्सिटी खोलता है, मलेशिया में यूनिवर्सिटी खोलता है, ये कहीं भी, तो एजुकेशन के सेक्टर में अगर एमिटी ने हर जगह, मतलब एजुकेशन एमिटी अगर अगर कोई और क्लासेस में अपना बिजनेस शुरू करता है, उसमें अगर उसने वेल नोन ट्रेड में अपने आप को रजिस्टर कर लिया है, तो फिर आप उसके ऊपर केस कभी फाइल नहीं कर सकते। ओके, सो मेन एग्जांपल यही है कि अगर आपकी क्लास डिफरेंट है, क्लास अलग है जिसमें आप फाइल कर रहे हैं, तो आप, यू आर द विनर ऑफ दैट ट्रेडमार्क। नेक्स्ट स्लाइड। नेक्स्ट, ये पेटेंट्स है। पेटेंट्स, हनी, नाउ यू कैन स्टार्ट।
Okay,
Ma'am?
so we'll now discuss about patents, which are another class of the IP. So, what is a patent actually? If you come up with any invention, so you can go for getting a patent on that, and for that you will get protection like for 30 years. You will enjoy the rights over your invention, and by getting a patent you would if when you get the patent for something, you enjoy the rights for 20 years, and you prevent any third party from selling, making, or using your product. So it is a legal document which is issued by the patent office, and monopoly rights are given by the government to the inventor. So patents are granted to encourage inventions, and so that it is for the mutual advantage of the users of the information, and for the patentee, that there is more of technological innovation happening. Patents are granted and rights are protected, and they are confined within the geographical limit of the country. So they're territorial rights, and they can be sold or licensed. So suppose a person becomes a patentee in respect of an invention, he can sell his rights to any third party, and in respect of some royalty, and he can license his patent. So next is just Yeah. So, what can be patented? Inventions in all fields of technology, whether products or processes, if they meet these three criteria, they can be patented. That is, the invention should be novel. It should not be known to the public before. The inventor has come up with the idea. If it's already known to the public, if it's already been used, then that invention, then that is not an invention, and then it cannot be patented. Then it should have an inventive step. Inventive step, not it should not be obvious to a person with ordinary skill. It should be something extraordinary. It should be having an inventive step, something new, and some technical advancement should be there. Or if it's some old product, but it is more economic, more sustainable to the user, so then it can be said to have an inventive step. And third, most important, that it should be industrially applicable. If you propose that your invention has some, I mean, if you're not giving any clear idea about how it is useful, then it cannot be patented. You have to obviously tell that how your invention is industrially applicable, how it has some commercial value in the market. So these three criteria are important, and they form the basis for your invention to be qualified for getting a patent. So suppose this is one folding portable iron. It is like a lightweight, weighing just 0.81 pounds, and it has a flat design that folds about the size of the palm. So this is something which is new, which is small, like it is handy. By spreading out the sides of the iron, you can use it iron a wide range of clothes like traditional iron. So these are type of inventions that meet the criteria for getting a patent, and therefore they are patentable. These are innovations. Then cost-effective nasofilter developed by a startup in 2016, and they used nanotechnology to build the filters, restricted the entry of particulate matter, including 2.5 pm particles and pollen allergens. So this device is very economical and cheap, like for just rupees 10. It has a filter that will cover your nostrils and protect you from the allergens. So these are things that are some patented. So next is types of patent application. There are different type of patent applications. It is provisional, ordinary patent application, convention application, PCT international application, then PCT national phase application, patent of addition, and divisional applications. So we'll discuss about them briefly, about each one of them. So provisional specification. So what happens is when you have come up with some idea which you have not completely worked upon, so you can go for you have come up with the idea, you have worked out a bit, but it's not completely worked out, so you can go for filing a provisional, you can file a provisional specification. So what it would actually do is it would give you a priority date. You would have that on this date you have disclosed your idea, so you would get a priority over someone who obviously if comes up with some the same idea, so you would have a priority over the other person. This guess you would file your application first with the provisional. Now with when you file a provisional, within 12 months of that you have to file a complete specification where you have to completely disclose the idea, everything about it. You have, so they give you this time period of 12 months where you will actually work out upon your invention. You will complete it in every aspect, and then within those 12 months you have to submit the complete specification where you're disclosing the entire idea, everything, the method by which you're working out your invention, and everything has to be disclosed. So in provisional specification, claims are not there. So these are actually techno legal documents where you're it's a legal document, but you're indicating the technicalities of your invention. So they're techno legal documents. So complete specification, it would begin with the title of the invention. Then you have to state the prior art. Prior art is actually the background, like what already exists in the market related to what you have made, what is already there, what is already known, and how your invention is better than what is already available in the market, or what new is there. If so, that is prior art. Then what are the objects of your invention, so that is mentioned. Then the summary is there. Then there is the detailed description of the invention is mentioned, which is followed by the claims. So claims are extremely important they're the most important part of the specification, because uh, what is claimed, what you have written in the claim is only what is going to be protected, is only what is giving you the protection. If you have not mentioned something in the claim, and you cannot claim, you cannot say that you are protected by it. So if you have written something in the claims, you will get protection for only that matter. And followed by in the specification is the abstract, which is just 150 words, and which you have to give a brief summary or idea about your invention, so that anyone who is searching the database for the for searching out similar patents, so it is the abstract through which one can make out whether the whether the patent is relevant to their whether the other patents are relevant to their patent or not. And the drawings are provided in the complete specification. For illustrating your invention, the drawings are provided. So next slide please. Then ordering application, if you're filing in the Indian Patent Office an application for patent without claiming priority in any other country, you're just filing that in India, so that would be a ordinary application. Then convention application is when you have filed a patent application, an application on patent filed in the patent office claiming a priority based on the same or substantially similar application. So if you're making an application in one country and within 12 months you're making that in another country, so that becomes a convention application. So next is PCT international application. So PCT is an international application governed by the Patent Cooperation Treaty. These are international applications. What happens is if a person wants to apply for patents in multiple for patents for a single invention in multiple countries, it becomes a very cumbersome process, because it's very expensive to go about and filing patent in each individual country. So what happens in PCTs, you have to file an international application, and then when you file an international application in the international phase, then after that you'll go to the national phase, and you have to, on the basis of international application, your application is processed in the national phase. So that gives a benefit. It's not it reduces the amount of time that is consumed in filing the applications in different countries, and also uh, the money that is spent in filing the application. So a PCT application is international application governed by the Patent Cooperation Treaty, and it is validated in up to 142 countries, and a single international patent application can be filed in order to seek protection for an invention up to 142 countries. So the priority date obtained by filing a PCT application is internationally recognized and has an effect in each of the countries designated. So you have to select the countries in which you want to apply, and once you make a basic application, the priority date is claimed when you make that international international application after you go for in the national phase. So within 30 to 30 months, then you 30 months or 30 to 31 months, you will enter in the national phase that is in the individual countries. Then patent of addition, what happens is sometimes when you have applied for a patent, then after some time you come up with some improvement in that existing patent. You have already applied for that invention for the patent procedure, or you for that invention you have already been granted the patent. So some, if you come up with any improvement or modification in that main patent, you can go for filing a patent of addition, and for that you won't have to pay any additional fees, and this patent of addition would be valid for the time till the time your main patent, that patent for your main inventions is valid. For the same duration, your patent of addition would also be valid, and it cannot be invalidated on the ground that it does not have novelty, but because your patent of addition is dependent upon the main patent for the main invention. So it is any improvement or modification, you need not go for a completely new patent. You can file for a patent of addition. Now next is divisional application. So what happens certain times is that the controller, when you file your patent application, they may say that your invention, the invention has multiple uh, inventions within itself. It is not, because the patents are always granted for a single invention. So if a controller suppose finds out that your in your specification two or three inventions are present together, so they may ask you to divide your application and file a further application in respect of your they ask you to divide. So that is a divisional application. You're dividing your main application and putting the matter in another specification, so that all of the inventions are present separately, and each of the application is related to only a single invention. So that's called divisional application. Now, next, who can file for a patent? A person who is the true and first inventor. Someone who is the inventor would be the is able to is eligible for applying a patent application in India, or a person claiming to be the assignee. If someone is assigning it to another person the right to apply, so that person is eligible to apply for patent application, or by the legal representative. So if anyone is legally authorized by the person to apply for the patent, they can go for filing. So a single person can file for a patent application, or multiple people can file out together jointly and go for filing a patent application. Next, please. So benefits of IPR, the benefits of IPR for like startups or academic institutes. So IPR, in order to, because startups have lesser amount of turnover, they have less turnover. So in order to encourage them, the government has been amending the rules and making them more favorable in for the startups. So they will now be eligible for 80% rebate in patent fees, as ma'am had already told, and they will DIPP will bear the facilitation cost on behalf of startups. And it will provide rebates and statutory fee for filing of applications. So filing patent applications is a little expensive process, because there are multiple forms, and the amount of fees that is required to be paid is towards a higher side. But for making the environment favorable for the startups to go for applying the patents, um, they have reduced the fees for them, and under faster clearance route, application fees for individuals and startups is just 1600. So they are revising the fees from time to time in order to make the process easier for the startups. Next. So the process of patent is like, first of all, a person comes up with some idea, so they will go to the patent agent or to some firm for getting their search done whether the invention that they're proposing is novel or not. So they will go to this to any of the patent analysts, or they can go about searching in the patent databases to know that whether the invention is novel or not, is something new or not. So that search is generated and they find out that yes, it is novel, they can go for getting a patent. So first of all, they will get the complete specification or the provisional specification drafted, and after that they will file it in the patent office, on the patent office website, which is completely digitalized, and it is filed there. So after filing, what happens is your application is screened and it is classified, and after that it is published. So what happens is the patent application is published within 18 months from the date of your filing. The day you're filing your patent application, from that 18 months, your patent application will be published. And in order, if you want that your application to be processed in a faster manner, you can go for expedite process. So under section 11A, it's published after 18 months, but by filing form 9 and paying rupees 2500 for a startup or a natural person, you can expedite the process, that is you can fasten the process, and then within 1 month only your publication your patent application is published. So this is how the publication document is. Once your application is published, the publication number is generated, and on the date it is published is mentioned. Then your title is mentioned, all the details related if it is an international application, or you have already come through a PCT mode, then it would mention all the priority date, documents and everything. But if it is not PCT application or convention application and it's ordinary, so just mention out the details of the applicants, inventors, their address, number of claims, abstract. So this is how a publication document looks like. And it has mentioned, like, suppose you can see it was filed on 21st of May 2019, and the process was expedited by this applicant, and it was published on 14th of June 2019. So this is publication. Now after your publication, the person who is making the application or any other person interested, who is someone who is conducting the research in the same area, they can go on for asking, they have to request for the examination. Unless and until the request for examination has been made, no application would be examined. So it would be examined only when the patent applicant or the any other person is interested is making a request within 48 months from the date of filing for the examination. And again, this examination process can be expedited like the publication process, and it would be examined earlier if you file form 18, for which the fees is rupees 4,000 for natural person or startup. So after you made the request for examination, your examination would be examined on the grounds whether they would examine whether the examiner is appointed, and they would examine whether the application is made as per the rules, as per the format that has been suggested in the act of 1970, whether the application has been made in accordance with that or not, whether your invention was is novel or not, or whether it has some industrial applicability or not. So these are the grounds on which they examine your patent application, and the examiner then gives a report to the controller, letting him know whether the invention should be qualified for the process of patent or not. So, who can go for expedited examination if someone is an applicant is a startup or it's a small entity, or whether a natural person, like if some there are individuals, group of individuals, and within that one of the individual is a woman, so they can go for filing a request for expedited examination. Everyone cannot go for getting the examination expedited. It is they see how much number are there. So in on the basis of that, then there are certain people only eligible for getting their application expedited. Next. So, as I had told, that once the examiner is submitting the report to the controller and it's found that all the criteria are met, it is novel, it has industrial applicability, it is not used before, it has not been published before, and all the documents that were made are in accordance with the provisions of this act, so the patent would be granted. And if there is any objection, those objections have also been met. If someone comes up with any opposition, that is, if any person opposes the grant and those opposition is also met, so the patent is granted and it is published in the IPO journal. And after the patent has been granted, they are required to pay the renewal fee every year. For like 20 years, the patent is in force. So for till the completion of 20 years, they have to pay the renewal fee every year. And in case the applicant is failing to do so, the patent would be lapsed. So they have to ensure that they keep paying the renewal fee in order to keep the patent in force, and so that they can keep enjoying their rights. And the renewal fee is applicable from third year onwards. So it is supposed to be paid only after the grant. So when the patent has been granted, right from the third year of your of the grant, you have to keep paying the renewal fee. Next. So this is the entire flowchart showing how the patent application is granted. So idea incubation phase, filing of the patent application with the complete specification, then there's publication, then there's request for examination. The examination happens, and after the examination, the report is given by the controller to the applicant, and if there's any objection, there's required to meet those objections and clarify them, and then the patent is granted. If at any stage uh, the objections are not met, or if the complete specification is not provided, then the patent would then the application would be abandoned. Next. So this mentions the patent application e-filing fees. So there are multiple forms required. Form 1 is there, Form 2, Form 3, Form 5, Form 9. The different forms for different purpose. So the fees for which is mentioned, there's separate fees for natural person. Like suppose it's an individual, so we refer to them as natural person, or a startup. They have equal fees to be paid. And if there is some education some large entity like a business firm or any bigger entity, so they are supposed to pay more amount of fees. So form 1 is 1600 for a natural person and 8000. Form 2 does not have any fee. Form 3 also doesn't have any fee. Form 5 also doesn't have any fee. Form 9, which is for early publication, 2500 is supposed to be paid by the natural person or a startup, and 12,500 by other than natural person. And similarly, the fees is there for different. Next. So this is how a sample patent certificate looks like. So once your patent has been granted, this certificate is generated with the patent number, the application number, on the date it was filed, the title, the patentee. So this is the document that is generated. Next. Now, what is copyright? So we have discussed about trademark and patent in quite a detail. Now, what is copyright? If you have any literary work, dramatic work, artistic work, you have written some book, or you have made some painting, or there's something, anything, or you have made some video or some movie. So everything, these things cannot be patented or they cannot be trademarked, but they are protected under the category of copyright. And then if you're getting the copyright over these work, so you get protection for a certain term of years, and over which only you can use your work and no other person, unless they get permission from you, they cannot use your work. So copyright is quite a familiar term with everyone. We see on YouTube videos, so sometimes they don't add up music in the background because that music video may be copyrighted. So copyright is granted for literary, dramatic, artistic work. And next slide, please. So, copyright is a legal term describing rights given to creators for the literary and artistic work, and it gives privilege to authors to reproduce, distribute, perform, or display some work. So, suppose you have published some, you have written some book, you can get a copyright over it, you can publish it, and you can sell as many copies as that. But if someone comes up, someone wants to translate your book or anyhow make any changes to it or make a movie out of it, first of all they have to get permission from you, since you have the copyright over that work, and then only they can go about doing any translation or making any use of that copyrighted work. So literary work, computer programs, musical work, also the computer programs, the software applications, they are not granted patent, but they are protected under the Copyright Act. Any sound recording, architectural work, they're all copyrighted. Next slide. So, importance of copyright is that they respect the individual intellectual rights of creators of information, and they reward creativity to authors, artists, musicians, and model proper behavior for students, teachers, and other members of educational society. So what happens is, while we may be, while we have been students and we are when we are required to make any of the projects, we simply go to Google, or we kind of go to any research paper and copy paste the text. But that is not advisable. Once if you are using any of the work which is available in the public domain and people have copyright over that work, you are supposed to give a reference of that work in reference of that person in your works, that yes, you have obtained the work, this copyrighted work of another person, because it would avoid plagiarism. Even when someone is writing thesis, they're supposed to write the reference, because they have written or quoted the work of some another person who would have the copyright over that literary work. So that is the importance of copyright. Next. Then copyright duration is like copyright in a literary work lasts for like 60 years from the time from the end of the calendar year in which the author dies, and 25 years for typographical arrangements of a published edition. So it is usually associated with civil law. And in the Copyright Act, there are provisions to treat all forms of infringement of copyright as offenses. So, next, to copy or not to copy, do not use, reprint, reproduce, or distribute without prior permission. Avoid plagiarism, and always acknowledge or obtain prior permission, as I've already mentioned. Next. Next. So this is how a copyright certificate looks like. So when you have been granted a copyright, they'll mention out the name, the number, the diary status. They would name out all the applicants, and what category of work it is, the title of the work, in what language your work is. So this is how a copyright certificate would look like once you have been granted a copyright. So this certificate is generated and given to the applicant. Next. Now, what are industrial designs? Uh, for some, like if there is some car, the features of it, the seat shape, the design of the seats, or of the headlights, or the if you come up with some like this furniture, some different kind of design of a chair, instead of getting, you will not get a patent about it, but for the external appearance you get industrial design registered. So if you, like the bottle of Coca-Cola, it is in the design is registered. No other person can make a similar design bottle, because Pepsi or Coca-Cola, they have got their designs registered. So those kind of bottle, so like for external appearance we get the industrial designs registered. Next. So, ornamental or aesthetic aspect of an article, the shape or the surface or the pattern, lines or color. Industrial designs are applied to functional articles, products of industry and handicraft. For like if there is a Sabyasachi outfit, So he will get his designs registered so that no other person can make designs similar to his, even though they are available in the market. People make, but he gets his design registered so that people cannot use his make designs similar to his designs and get benefit. So the housewares, electrical appliances, luxury items, so vehicles or textile designs, they're judged solely by the eyes, the industrial designs. So if you want to get them register any of your designs registered for something, if you're making something, you want to register its design, you have to go and search on the website whether something similar of the sort design is existing or not. So if it's not there, then you can proceed with filing the industrial design application. So it is granted for a term of 10 years initially, plus 5 years renewable. Next. So what is not registrable? Something that is not new or original, which is already known to the public, what the public has already seen, or which is not significantly distinguishable, or something which is contrary to public order or morality. So these things cannot be industrially registered. Next. Next, please. Hello.
Just a minute, madam. It is loading.
Okay.
काय प्रॉब्लेम आला?
Back. Back. Yeah. So next. So these are registered designs. This one is a registered design of Samsung Electronics. So there are different like mobiles available, all of different designs. So designs are registered. Okay, yeah. So Apple is there. They would. Why is the cost of Apple products on a higher rate? Because they get so many patents for the technology and also for the design of their product. So there are different designs of different applications which can go for registration, and the person can enjoy the benefits of registration. Next. Next. So you can see here it's a smart alarm clock here. The perfect alarm clock for those who can never get out of bed. It's until you step up on this alarm clock, it will not stop snoozing. So when the person would stand up on this clock, only then it would stop ringing. And these are examples. Like then this is a cup which catches drops of tea and coffee. So the special design of the cup allows it to collect up all the drops rather than having the rather than them staining the table. So there are different designs people come up with different designs and different innovations which cannot be patented, but then they qualify the criteria for getting their designs registered. Next, then this is the certificate which is generated when your industrial design is registered. So all you need is for filing your design application is first that you need to see whether that something of the similar design exists in the market or not. And if it's not there in the market, you can go about filing a representation sheet in form 1, in which you have to disclose the details of the applicant and also give views, that is different sided images of your design, the left hand side, right hand side, top, bottom, perspective. These all views you are supposed to submit, and then the application is processed in the design office Kolkata. And if they find out that your design is something new and should be registered, they would grant you the industrial design, and then they'll give you the certificate. Next, now, geographical indications. Suppose you would have heard about Fulkari Chunni or Agra ka Petha. So, certain regions have some speciality. So, they get this GI tag, and it is the name or sign used on goods originating from specific geographical origin or location and possesses qualities, reputation, or characteristics that is essentially attributable to that place of origin. So, Nagpur ke संतरे या कोल्हापुरी चप्पल, all of these things, Kanjipuram sari, so all these things are specialities of that place. So they have been given GI tags in order to promote the interest of the people who are actually working in developing these or making these items. So GI tag is given, and Darjeeling tea ho gayi. Next, so there are different regions here. You can see the GI tags of India. There are different regions which are popular for different things. Next, recent GI tags of India: the Tamil Nadu's Panchamirtham Prasadam, then the Kandamal Haldi coffee varieties, road turmeric, Marayur Jaggery. So there are different things which these are the recent GI tags of India. Next, so this is how a GI certificate looks like when you're. It is granted to a group of people, not to some individual. So it's a certificate that's generated. Next. So the T-board, here's a case study on the T-board India versus ITC Limited. T-board India versus ITC Limited may be the first case on infringement of a registered geographical indication to be decided by an Indian court. So the Calcutta High Court denied an interim injunction to the T-board of India, the registered proprietor of GI Darjeeling. The T-board issued the IDC company inter alia under the Geographical Indication of Goods Act 1999 for the infringement of its registered GI against the use of the name Darjeeling Lounge. Reaching such use amounted to an act of unfair competition, including passing off. So this company would have used the term Dazzling Lounge, but the T board sued the company because it was infringing a well-known GI tag. Next. So trade secret, any confidential information that provide a company with competitive edge, could be an invention that does not fulfill patentability, and advantages include longer protection. So sometimes what happens is when you go for applying for a patent application, ultimately after 20 years, your application it would be known to the public because all your rights would be gone by then. And after publication only, the patent is available for public inspection. People can see or have an access to documents. So certain things which you don't want to get patent for, you can go for getting the trade secret. Like Coca-Cola, they never reveal the ingredients or how the process of making the beverage is. So that is a trade secret because they're not disclosing it. They don't want to disclose it, and therefore they are going for obtaining any patent, because ultimately after a certain duration of time, all the rights would be gone and everything would be open in the market. So in order to do that, they would get a trade secret, which would obviously give them a longer protection and would be cheaper. unlike patent. So they're not supposed to pay any fees for that. But disadvantage is any leakage of information. So there's a risk for the leakage of information, and reverse engineering can happen. So then your trade secret can be in problem. Next, so the best kept secret till date is by Coca-Cola. They have not revealed how they go about making the beverage. Next, so example of potential trade secrets is formula of some sports drinks, recipes, marketing strategies, manufacturing techniques, and another example of famous trade secret is KFC chicken recipe. So they never let another people know, nor they go for applying a patent. So Coca-Cola made a choice to brand the recipe a trade secret instead of patenting it, which would have led to disclosure of the ingredients. And one of those ingredients may have been cocaine. Coca-Cola decided to keep the recipe as confidential information, and this trade secret has spawned rumors of its own. One is that the recipe contains bugs or insects, and another is that two employees each know only half the recipe, or that only two people know the combination of the safe where it is stored. So they never let the employees also completely know what combination of ingredients they are using, and there are different myths and rumors about how and what is present in the beverage. In case you doubted, corporate espionage is real. In 2006, an employees and two accomplices stole the formula and tried to sell it to Pepsi. Pepsi blew the whistle and let Coke officials know what was happening, and the employees and the friends were arrested. So, if you think that trade secret can be let out, so obviously it can lead to the people who would try to leak the information as well. So it wouldn't won't be any good idea for the people or the employees there to let the secret out. Next, so if anyone these have been the useful links for preparing the PPT. If anyone wants to ask something or any queries, can surely let us know. Let me know.
Okay, there are certain questions, Hanit ma'am.
Yeah,
I would
sure.
like to answer. So I'm going to display here. The Mayur Bodhankar asked, I want to issue copyright for my handwritten notes. What will be the procedure that I have to follow?
For that, you will have to submit your work, your handwritten notes. In case you have not copied them, it's your original. I mean, you have compiled and written in your own words. So you would need a Form 14, where you'll give your details if you want the copyright in your name, or if it's not in case of or if you want the copyright to go in the name of the university, you will have to name out the applicants and the author who would the title of the literary work. So Form 14 is required. And if suppose you are the author and you want the copyright in the name of the university, so you'll have to give an NOC to the university that you're okay with them getting the copyright in their name. But if you want that in your name, you have to just go for filing Form 14 on the official website of the Copyright Office. And once then when you filed it, you will make the payment. You will have to upload your work, and your application will be scrutinized at the Copyright Office. If they find that your work is new, so they will go about giving you the copyright. So that is how the procedure you have to follow.
Okay. Thank you, madam.
I hope I'm able to clear.
Yeah. One more question from Pharma Heart. That is, I think they got patent, but after someone has opposed
जब
it, the opposition करके ऐसे आ रहा है.
जब हमने कोई पेटेंट लिया है, सडनली किसी ने उसका अपोज कर दिया, तो उस प्रोडक्ट पर अब रजिस्टर्ड की जगह अपोज लिखा आएगा. See, actually, what opposition can happen at two times. So one is either before your grant or after your grant. इफ बिफोर हम लोगों ने कोर्ट में अपने 10 साल पुराने बिहेवियर में रिजल्ट आया, फिर उन लोगों ने वापस हाई कोर्ट से कर दिया, तो अभी सब प्रोसेस में इसका कोई सोल्यूशन है? See, I am not very much knowledgeable about the patent prosecution step at the later stages, so probably I will not be able to let you know. But I will surely ask Pooja ma'am if she can suggest you how it is. Yeah, so I am not much knowledgeable about the prosecution phase in the later stages.
Okay.
Okay, thank you, ma'am.
You're
Uh, I,
welcome.
f- okay. I feel honored to get the opportunity to propose a vote of thanks for today's webinar on behalf of Kokkan Gyanpit, Rahul Dharkar College of Pharmacy and Research Institute. I extend a very hearty vote of thanks to the resource persons, Hanit ma'am and Pooja ma'am, for today's webinar, for giving your valuable time and sharing with us your findings, your opinions, and also discussing various case studies. Next, I convey my regards and hearty thanks to all the teaching staff, technical staff who put their persistent effort to make today's program a successful one. I would also like to thank our principal, Dr. Mohan Kale sir, whose guiding vision always motivates us to strive for the best. I would like to convey my regards to management, without whose support the event wouldn't have been possible. And yes, thank you to all participants for patiently attending the webinar. With this, I hereby conclude the webinar. Thank you once again for cooperation and patient listening. Have a great day ahead.
Thank you for having me.
Thank you, ma'am.